Hey guys, so I want to talk to you today about why your waivers don't protect BJJ and MMA gyms, really in any state. So if you own a BJJ gym or mixed martial arts gym, some sort of martial arts combat sports studio, your waiver is probably not protecting you, and courts across the country agree on this. So I'm an asset protection attorney, and I train, coach, and compete in Brazilian Jiu-Jitsu. Now, combat sport gyms are legally different from normal fitness gyms because they involve intentional physical contact or just controlled violence, not accidental exercise injuries. So the reality is that assumption of the risk has limits. So in California, for example, in 1992, in the case Knight versus Jewett, the court held that participants assume inherent risk, but not risks that are unreasonably increased by someone in control. The non-legalese translation of this is that coaching decisions can destroy assumption of the risk defenses. And a few easy examples are pairing partners up, teaching advanced techniques like heel hooks to beginners, or jumping guard, flying submissions, or rolling back takes. And the big misconception is that waivers are not a shield, and this is nationwide. So gym owners rely on waivers, and for some reason, you think that they are the holy grail. But the law doesn't. They don't agree with you on this at all. In California, waivers fail for gross negligence and instructor conduct. We have the city of Santa Barbara versus Superior Court case that held that waivers cannot release gross negligence, and courts routinely treat reckless coaching as crossing that line. In Oregon, it's substantially worse. Recreational waivers are even weaker. In Bagley versus Mount Bachelor Incorporated, the court invalidated liability waivers when businesses control safety conditions. And this is exactly how BJJ and combat sport gyms operate. In New York, waivers are largely prohibited by statute. So, under General Obligations Law, Section 5-326, and cases like Lago versus Crowledge, paid athletic facilities cannot enforce waivers for negligent instruction or supervision. In Florida, it's substantially worse. Waivers must be crystal clear, and they still fail when instructors escalate risk. In Sansilo versus Grive Kids the World, or give Kids the World, the court reaffirmed that waivers are strictly construed against businesses and do not bar claims outside their exact wording, especially negligence tied to supervision. So the Florida courts ask a simple question: did the injury happen from the activity the participant thought they were consenting to, or from something materially more dangerous introduced by the instructor or the facility? A few examples would be mismatches known to the instructor, or students following the instructor's authority when you're saying, like, trust me, or it's okay, you'll be fine, or open rolling with higher belts, competition speed sparring, king of the mat drills. And these are all common in every gym, but legally they change the nature of the activity, or failing to intervene when risk is apparent, like when a panic sets in, or fatigue, repeated failed taps, dangerous positioning. In Texas, waivers do not protect against gross negligence or negligent instructions. So we're starting to see this pattern, right, in similar wording, right? The Texas Supreme Court confirmed these limits in the Jim NI Playgrounds versus Snyder case, allowing claims to proceed despite signed releases when safety duties were breached. And in Illinois, waivers collapsed when gyms again controlled training decisions. Courts have consistently held, including in Hawkins versus Capital Fitness, that exculpatory clauses do not bar claims for negligent supervision or instruction. So we have different statutes, different states, but the same outcome. Waivers fail when instructors control the risk. Now, here is the case that every gym owner needs to understand. The verdict in this case made this impossible to ignore. In California in 2018, a beginning student, Jack Greener, was training at Mar Jiu-Jitsu Club. During sparring, a black belt instructor executed a flying maneuver that drove full body weight onto Greener's neck. Grainer suffered a catastrophic cervical spine cord injury and he was left as an incomplete quadriplegic. So in 2023, a San Diego jury awarded about $46.5 million, and the California Court of Appeals 4th District affirmed the Grainer ruling. By 2025, after post-judgment interest and after the California Supreme Court declined to review it, full exposure exceeded $56 million. So why did every defense fail? The appellate court held the instructor unreasonably increased the inherent risk of BJJ. Primarily, assumption of the risk defense failed and the waiver that they had him sign failed. And why is that? Because the courts treat instructors as the experts in control, especially when dealing with beginners. Now, here is the part gym owners miss. This wasn't a freak accident. It was a coaching duty failure by law, legally, by duty, whether you agree with it or not. When the owner is also the coach, liability follows conduct, not paperwork. And no commercial gym insurance policy writes 8-figure checks. This means verdicts like this blow past policy limits, meaning personal assets, your home, stock accounts, rental properties. They're going to fund that gap. So if your insurance provider didn't just walk away from you already and deny the claim from the very beginning for gross negligence, you're stuck with that verdict all on your own. So what you can do here, what is the legal structure reality here for you? Gym owners who survive lawsuits don't eliminate liability. They contain it, just like containing an untrained spazzy white belt. Proper pre-incident layered legal structures redirect exposure away from homes and away from savings accounts and retirement accounts and away from investment properties, away from your businesses. You layer out your assets and risk into separate LLCs and then create protection barriers above them with things like management companies, limited partnerships, and asset protection trusts. Now, California produced the biggest verdict, but the waiver and coaching duty rules, they apply in, California, Oregon, New York, Florida, Texas, Illinois, basically every state. So if you run a fight gym or a combat sport gym, jiu-jitsu gym, some kind of martial arts, the time to fix this is before someone gets hurt, because after that, the law locks the doors.